suppose first, the context of the event today. At the Reykjavik summit in 2023, in quite a display of unity following Russia's full-scale invasion of Ukraine, the Council of Europe member states reaffirmed their unwavering commitment to the ECHR, the European Convention on Human Rights, as being the cornerstone for promoting peace and stability in Europe, based on the values of human rights, democracy, and the rule of law. But since then, we've seen a pretty dramatic deterioration. Far really from being united around values, there appears to be a growing group of states that are intent on upending the human rights framework, for better or for worse. There is clearly political discontent with the European Convention on Human Rights in some countries, or at least it's being framed as making life more difficult for governments that are trying to address some key public policy challenges like migration or security. It is also a fact that more than a dozen states are more or less actively discussing proposals for reform of the system, up to and including outright withdrawal from the Convention, or even the Council of Europe itself as a corollary of that. Some states seem to favour reforms that are even diametrically opposed to well-established international law, or run contrary to their own interests to ensure a kind of an efficient, effective, fair, and accountable justice system. And coupled with all of that, it seems that the space for discussing these kinds of issues is diminishing. Our interest today is not to necessarily play to politics, but to actually consider the facts as they currently stand. And as tempting as it might be to dismiss political statements as being populist or otherwise, I really would discourage everybody from that narrative. And I instead would invite everybody to engage in an open, honest discussion, an evidence-based discussion on the merits of the human rights system, the risks of reform, and so on. We have 5 superb speakers today who are going to share their views on whether recent criticisms, the risks involved, and how the system might respond to these various developments. Today, we also mark the official launch of the AGORA Group, which is a new independent pan-European platform dedicated precisely to open discussion on the ECHR. But before we go any further, it's really my pleasure to invite Professor Derek Hand, the Executive Dean of the Faculty of Humanities and Social Sciences here at Dublin City University, to offer some introductory remarks. So Derek, over to you, please. Thank you.
Okay, thank you, Andrew. Look, it's a great honour for me to welcome you all to this event. Here in Dublin City University, our mission is to transform lives and societies. And an event such as this, I think, is a great example of the kind of things that we try to sort of do. Because what we want to do is, I suppose, make impact in the world with real world problems. And I think today's discussion is exactly that. I want to welcome all our participants, and in particular the distinguished speakers. So we have Senator Adam Bodnar, former Minister of Justice and Attorney General of the Republic of Poland. We have Professor Alice Donald from Middlesex University. Professor Veronika Fikfak, University College London and University of Copenhagen. Professor Mikael Madsen, University of Copenhagen. And Professor Colin Harvey, Queen's University, Belfast, and also Commissioner on the Irish Human Rights and Equality Commission. As Andrew said, there are significant policy challenges facing European states at present, from defence and security to migration to housing and access to public services. And some of these issues appear to amplify political divisions and affecting social cohesion. The ECHR has become a ground zero for political backlash against the role of international law in national legal systems, with serious questions being raised about the future of the system itself. The Dublin European Law Institute, DELI, and Dublin City University prides itself in excellence in all matters concerned with European law and policy, including European human rights law. So that's why it's such a great pleasure for me to welcome you to DELI and DCU's important discussion today. I note that my colleague and good friend Federico Fabrini is here as well, so it's good to see you, even if it is only virtually. And I wanted just to call out Andrew as well for all his hard work in putting this together, and Charlie and other colleagues in DELI. The aim of this event, as Andrew said, is to facilitate an open, evidence-based and constructive conversation about the current situation, the prospects of reform, as well as some of the risks of politicizing Europe's key human rights organization, the Council of Europe. And as again Andrew said, we are formally launching the AGORA Group, an initiative from Andrew and as a member of DELI. So I wish you all well for your discussion over the next hour and a half. And just to reiterate, it is a great honor and pleasure to be able to welcome you here to DCU. So thank you very much.
Sincere thanks, Derek, for your time. Much appreciated. And with that, I will move directly to the next stage of the event. I want to introduce our speakers in a little bit more detail. Thanks to Derek for giving a quick overview, but I'll just start firstly with Adam. So Senator Adam Bodnar is a Polish senator in the upper house of the Polish Parliament, a scholar and an expert in constitutional law and human rights. He served as Minister of Justice of Poland from 2023 to 2025, and as Ombudsman or Commissioner for Human Rights of Poland from 2015 to 2021, during which time many of us on this call will have known Adam because he was very outspoken in his defense of fundamental human rights issues. He has been involved in numerous different organizations like the European Institute for Gender Equality, UN Voluntary Fund for Victims of Torture, the UN Agency for Fundamental Rights, and so on and so forth. So, Adam, we're delighted to have you. I'll run through our next speakers before I give you the floor. Next on my list is Alice, Professor Alice Donald, Professor of Human Rights Law at Middlesex University. Alice's research lies in the field of human rights implementation and the relationship between human rights and democracy, with a focus on the role of parliaments and the European Convention on Human Rights. She also writes regularly on the UK's relationship with the ECHR system, and recently co-authored an excellent report published by the Bonavero Institute at Oxford University on the European Convention on Human Rights and immigration control in the UK, informing the public debate. Alice is a trustee of Just Fair, which works to bring social justice and human rights together by championing economic, social, and cultural rights in the UK. Alice, great to have you with us. Thanks again. Turning now to Professor Veronika Fikfak. Veronika is a Professor of Human Rights and International Law at the University College London School of Public Policy and a co-director of the UCL Institute of Human Rights. Veronika has just completed a 6-year European Research Council funded project on execution of judgments of the European Court of Human Rights, in which she studied the dynamics of compliance in countries where the rule of law was under attack. She's currently judge ad hoc at the European Court of Human Rights, an expert member of the Advisory Committee of the UN Human Rights Council, and a member of the Permanent Court of Arbitration. She's also part of a working group of the Committee of Legal Advisors on Public International Law at the Council of Europe on enforcing the European Court's damage awards against the Russian Federation. You're very welcome, Veronika, and thanks a million for being with us. Turning now to Colin. Colin Harvey. Professor Colin Harvey is a Professor of Human Rights at the School of Law in Queen's University in Belfast. He's a good friend, a colleague of mine, and a commissioner on the Irish Human Rights and Equality Commission. He's also a member of the Scientific Committee of the EU Fundamental Rights Agency. Professor Harvey is the editor of a book series, Human Rights Law in Perspective. He's an extensive record of leadership, scholarship, public service, and civic engagement over a 30-year career in higher education. Colin, thanks for being with us. And last but certainly not least in my list is Professor Mikael Madsen. Mikael is a Professor of European Law and Integration at the Faculty of Law in the University of Copenhagen and a Director of iCourts, Centre of Excellence for International Courts. Trained as both a lawyer and a sociologist, his research focuses on international law and institutions and the evolution of the legal profession. He is the author of numerous books and articles, including International Court Authority, co-edited with Alter and Helfer, and Sovereignty, Substance and Public Support for the European Court's human rights rulings in the American Political Science Review. So you're very, very welcome, Mikael. Thank you all for being with us, and I hope the participants can see just the high quality and high caliber of speakers we have today. So without further ado, I'm going to now turn to you, Adam. I'm very pleased to invite you to take the floor and deliver a special guest address for us. I'll say no more and I'll leave it to you, but we might come back to you with some questions later. Okay, Adam, the floor is yours. Thank you very much.
Ladies and gentlemen, dear professors, thank you very much for invitation. It is really a great honor for me to speak to you and to whole audience. I think that we are living in extremely difficult times for the system of human rights protection. And I really regret to say that European Convention may become victim of those times. But I would like to start by saying that for Poland, for my country, the European Convention is of special value because it had important role in the process of the legal and political transformation since 90s. And interestingly, Poland was one of those countries that benefited from the convention system because thanks to it, we could, on the other one hand, change and modify Polish legal system. But on the other hand, Poland could contribute to the development of the system of the convention. I would like just to mention the role of the pilot judgments. First two pilot judgments were the first two pilot judgments concerned Polish cases. Over the so-called illiberal time in Poland, 2015-2023, there were some attempts to undermine the system of the convention. We had two judgments of the Polish Constitutional Court that which became, in meantime, politicized institution. And in those two judgments, the the Polish Constitutional Court said that Article 6 of the Convention is basically could be contrary as interpreted by the European Court of Human Rights with Polish constitution. But I would say this approach towards the convention system was a kind of a sign of illiberalism, because on the other hand, we could see number of judges, number of NGOs, victims from different vulnerable groups, including women's rights groups, LGBT plus groups, that were fighting for their rights with great success, with great prominent, important judgments of the European Court of Human Rights. I think the turning point, in my opinion, in recent years for the European Convention was the Reykjavik Declaration. And I think that we should underline why Reykjavik Declaration was adopted, because it was just a reaction to the Russian aggression on Ukraine. All member states, all heads of states, prime ministers gathered in Reykjavik in order to signal that there is a need to support and to strengthen the convention system. And second, I would like to mention that it was just 2 years ago that the Reykjavik Declaration has been adopted. And in my opinion, we do not see kind of a big change in terms of political situation that would legitimize attempts to undermine the convention system. Moreover, what happened after the Reykjavik Declaration is also, I would say, the change that happened in Poland. So please note that starting from December 2023, Poland started to be an active, once again, member of the Council of Europe. Last year and last month, Polish Prime Minister Donald Tusk hosted 2 times visits of the presidents of the ECHR, both Marco Bośniak and Mr. Gulojmor. Moreover, Poland made a proper competition for the new judge of the European Court of Human Rights that is regarded as a kind of a high-level standard competition for the position of judge. And moreover, Poland has declared that it is going to comply with all the judgments concerning rule of law and judicial independence. And so, for example, Poland did not appeal against chamber decision in Lech Wałęsa against Poland case. I say it not just to underline what happened, but basically, in my opinion, it is not just a sign of attachment to European values, but it is also a sign of a political support to the system of the European Convention. Moreover, when I was the Minister of Justice, Poland was pretty active. We organized a special seminar devoted to European Union joining the European Convention on Human Rights, and I do believe that still it is the topic for the EU, that European Union should join the system of the convention. Okay, but there is, of course, something wrong that is going on, something that is potentially dangerous regarding the convention system, which is, of course, the problem of migration. Please look that in the Polish context, but it is not just Polish context, it is the context of countries bordering with Russia or with, or at least having, or with Belarus. We have this problem of using the human rights system in order to undermine the, let's say, political stability and the political situation in different Council of Europe members and in different EU member states. And that is why such countries, first like Finland, but then Poland, but then also Baltic states, started to use a practice of, let's say, approving the practice of pushbacks, and at the same time undermining, or maybe not undermining, but at least putting in question the Geneva Convention system for the protection of refugees. And the new notion has been coined, which is called so-called weaponization of migrants. And to be honest, that is how it works. It works this way, that regimes of Lukashenko and Putin are taking advantage of migrants coming from different southern countries that are brought to Minsk or to some other cities. And then there is an attempt to cross the border and take advantage of the fact that if somebody is at the border, then this person may submit application for the asylum. And then if this person is approved on the territory, it is almost impossible, if not extremely difficult, to make any return procedure with respect to this person. And please look that in the Polish context, that kind of a situation is questionable from the point of view of the policy of the state, because if Poland, and it is the case, is subject of the hybrid war that is instigated by Russia, if we have different acts of sabotage, espionage, disinformation, manipulation in elections, or putting fire on the shopping malls, then basically the situation at the border is just one of many aspects of these issues. And that is the reason why my feeling is that Poland is joining effort by some other countries to have a different look at the system of human rights protection from the point of migration. That is why Poland is concerned to what extent the jurisprudence also of the European Court of Human Rights may lead towards some unpredictable consequences that will be later used to the benefit of the Russian Federation. And but in my opinion, even if there is that kind of a concern should be subject of a regular discussion, maybe through the intergovernmental conference, through the intergovernmental dialogue, and there were examples from the past when that kind of a dialogue was taking place in order to resolve different problems connected with the convention, but not necessarily with undermining the credibility and independence of the European Court of Human Rights, as well as not with attempt to withdraw or to challenge the system of the convention. Because at the end of the day, if we have the system which is not stable, if we have the system in which Russia is undermining our values, we should not at all lead our effort towards undermining values in which we believe. We have built those values and this system starting from 1950 throughout last 15 years, throughout last 75 years, in order to protect ourselves from the threat of authoritarianism, totalitarianism, threat and consequences of the Second World War. And European Convention became a part of the European identity, something that connects us all. And I think we should stress what is the value of the convention to regular citizens, what is this transformative value of the convention for the legal systems, and moreover, we should even stick to the original text from the Reykjavik Declaration, what countries should do in order to support the convention, and what they should do in order to implement all those provisions and commitments that were made at that time, including the joining by the European Union of the European Convention on Human Rights. Once again, Reykjavik Declaration was supposed to be a response to Russian aggression, and nothing has changed. Russian aggression is still there. Ukraine is suffering heavily, and we as EU member states or Council of Europe member states should be strong in order to resist any temptation to undermine our liberal values and instruments of legal protection. Thank you very much for your attention.
Thanks, Senator Bodnar, very much for that. A very clear message of support for the system, as you said, that we have built up collectively over decades. And I think you make a very persuasive point that circumstances haven't changed fundamentally since the Reykjavik Declaration. So why should states regress from those commitments? So many thanks, Adam. I'm going to turn now to the panel, but we will come back to you with some questions maybe later, Adam, if that's okay. First on my hit list is Alice Donald. Alice, you've been following these developments both as a expert academic, but also as a citizen of the United Kingdom for a long time. Can you maybe share with us your initial reflections on where we are, both in terms of the UK, which I think is a specific case, perhaps, but also more broadly in the wider Council of Europe area?
Yes, indeed. Thank you, Andrew. And it's just an absolute honour to speak straight after Adam. Yeah, so reflections on the UK. Here I'm really going to bring the mood down. I guess colleagues present will know that the Reform UK party, led by Nigel Farage, currently leading in the polls here, says that withdrawal from the ECHR would be a day one priority for any government led by Reform. And I think we should also recognise that this is kind of a full frontal attack, not just on the ECHR, but on international law generally, because Reform has also said that it would suspend, without seeming to realise this isn't possible, the Refugee Convention, the Convention Against Torture, and the Council of Europe Trafficking Convention. Since then, very recently, the centre-right Conservatives have followed suit in terms of saying that they would withdraw from the Convention and the Council of Europe Trafficking Convention. And they wouldn't leave the Refugee Convention, but would, quote, legislate to prevent courts from having regard to it in asylum cases. I'm still trying to get my head around that idea. So I think both of these parties in the UK are in a kind of arms race of Trump-style measures, really, threatening, mass detention, deportation of hundreds of thousands of people with no due process, and now even, in fact, threatening deportation of legally settled migrants in the UK if, for example, they claim any state benefit or if their income falls below around £39,000 a year for more than 6 months. That's about €44,000. So this is a threat to deport legally settled people in the UK. So these policies are unworkable, impracticable. Much has been written about that. They vastly overestimate the effect that the convention has on immigration decisions, and they deny or ignore the fact that being out of the ECHR would in fact, of course, hinder border control by destroying the basis for multilateral cooperation. But I thought it'd be useful maybe just to look, and I hope also to compare. This is really one of the value of the AGORA Group as a platform where we can kind of take stock and follow developments across Europe. What are the political dynamics at play here? Because I think certainly in the UK, possibly elsewhere, withdrawal from the UK, or shall we say aggressive reform talk, has become almost like an article of faith, a kind of virility test for politicians who wish to signal that they're serious about irregular migration. So, for example, here the Conservatives have made support for ECHR withdrawal a condition of actually becoming an election candidate for the party. They might come to regret that, but that's what they're saying. And the debate has become, I think, dangerously detached from reason, from evidence, fueled, and again, I'm sure this is familiar across the continent, by relentlessly negative, inaccurate media reporting, especially here, of course, on the highly salient issues of small boat crossings across the Channel and the deportation of foreign national offenders. It's also, I think, notably been fueled by a small number of very well-funded think tanks, very opaquely funded think tanks that represent really a tiny, thin stratum of legal opinion. It's so thin, in fact, that it's almost akin, I think, to the position of climate change deniers, those standing out against the, scientific consensus. But the difference in the UK is that, unlike the climate change deniers, the withdrawal position has now become mainstream, and not least due to the dominance of reform or conservative supporting media. And that's before we get to social media and the existence of kind of radical conservative material online, racist, misogynistic material included, which is ideologically hostile to equality, contemptuous of authority, of institutions and expertise. So what I think is really worrying here, certainly in the UK, for the ECHR and international law generally, is the way in which they've become in mainstream politics here so central to this kind of disruptive sort of smash the orthodoxy positioning. But this is an argument that current polling in the UK, at least, suggests is successfully connecting a pervasive sense of disempowerment and cynicism about politics with hostility towards and scapegoating of immigrants, people seeking asylum, and indeed other sort of disliked minorities. So in this scenario, perversely, I would guess to many of us, the ECHR is the bad guy, the source of injustice, acting against the interests of those pushed to the margins in society. So I think it is becoming a kind of existential issue for international human rights law. And I would pause here just to commend Rapporteur Olivier de Schutter for his report just this week on how rolling back protections for people living in poverty has created fertile ground for far-right movements across Europe, across the world indeed. And his proposed solution being investment in universal rights-based social protection. But just to bring it back to the ECHR, I think here the Labour government in the UK is struggling to respond, caught between, in a sense, an attempt to pander to this narrative on the one hand, and on the other hand, its better instincts and, of course, fear of losing votes also on its left-wing flank. Labour is quite clearly opposed to withdrawal, as are the Lib Dems, the Greens and the smaller nationalist parties, but nor has Labour been full-throated in its defence of the convention. And I think in conversations that we've been having, even with very supportive Labour MPs, there's talk really of the need to be seen to be doing something, be that national legislation to restrict the application of rights, or reportedly now the UK's involvement with an enlarged group of European states pressing for reform in Strasbourg. But this brings me to my second point that Andrew asked me to address, which is what reform exactly at the European level. So I think it's important to state that the UK is, for now, at least an outlier in Europe. I think elsewhere, kind of pushing back but not pulling out of the convention is the broad reality of centre-right politics at the Council of Europe level, with calls for withdrawal confined largely to the radical right fringes. And even then, it's useful to note that, for example, National Rally in France or the AfD in Germany do not, at least currently, espouse a policy of withdrawal. But I think we should also make clear that calls for withdrawal are just one very damaging end of a spectrum of other damaging and, I would say, irresponsible state interventions this year, which have been mostly rather oblique and secretive, starting, of course, with the Letter of Nine in May, engaging in a kind of megaphone diplomacy, if you like, with interventions that talk loosely of reform, but without adducing evidence as to what exactly needs reforming and why. So we've seen these disparate interventions, of course, led by Denmark and Italy, the Belgian Prime Minister claiming to have drafted what he calls a restrictive interpretation protocol for states, proposals to get more conservative judges elected to the court, and even remarks attributed to, although not directly quoted from, Donald Tusk, Polish Prime Minister, saying that if the 46 states can't agree on how to modernise the convention, it would be reasonable to think about leaving it. But I'm not sure if those were his exact words, so we need to look into that. So I think the conduct of the 9 states in this now enlarged group seems designed to exculpate national actors, I would say to scapegoat the court in particular for domestic discontents around immigration, often, of course, discontent inflamed by the very politicians who now seek to externalise responsibility to Strasbourg. And meanwhile, there's a whole group of other states who are remaining silent. So in terms of what should happen next, and I want to just draw to a close here, Andrew and I have written a piece for EGIL Talk that was published yesterday about the various scenarios that have kind of gained political attention in Europe. And we conclude, I won't go through them all now, but that far from being well considered, legally robust, practicable options, that several of those being discussed appear unworkable, inconsistent with the object and purpose of the Council of Europe and the Convention, such as suggestions for an additional protocol that would not require ratification by all states, but that would restrict the court's interpretation of convention rights for those that kind of opt into it. So this creates the risk, of course, of generating a sort of multi-track, multi-speed convention system with no doubt significant unintended consequences, both for the states advancing them and the wider Council of Europe. And certainly in the UK, of course, some of those consequences would manifest most dramatically and dangerously in Northern Ireland with the destabilisation of the Good Friday Agreement, which I know Colin will talk about. So Adam and I concluded that piece with exactly what Adam was talking about just then, the need for an intergovernmental dialogue using established legitimate channels which are open to states, akin to the Steering Committee for Human Rights, which brings together state representatives, the Council of Europe institutions, and is also open to civil society with the potential to draw on external expertise. The potential for a new political declaration 2 years on from Reykjavik as well, which would not only be directive for the Council of Europe, but also persuasive towards the court. But I think the imperative, and indeed that's why we're all here, that's why AGORA was created, is for precisely evidence-based, transparent, inclusive reflection on the consequences of proposed reforms and an end to this frankly destabilising and opportunistic manoeuvring that we're seeing at the moment. And I'll leave it there, pass on to the next speaker. Thank you.
Thanks, Alice. I think it's really interesting to hear you also calling for this, a discussion, but through legitimate channels rather than the kind of back channel discussions we've seemed to be seeing so far, and also outlining the specific circumstances in UK politics. I wonder though, and maybe that leads me to the next speaker, whether the ECHR is also the bad guy in Denmark. So, Mikael, can I maybe turn to you now, please? Thanks, Alice. Denmark seems to be, in a sense, at the forefront maybe of discussions regarding reform of the European Convention on Human Rights, or maybe I should say reform in inverted commas. Can you maybe tell us a bit more about what you think motivates Denmark in this regard, and what is Denmark exactly trying to achieve from your perspective? Thanks very much.
Thank you very much, Andrew, and thank you very much for inviting me to speak here today in this in fantastic company. So I will indeed say a little bit more what I could sort of dig out about the Danish initiative, sort of its background, and how it's different from the pushback we saw in the context of the Danish chairmanship of the Council of Europe some years back. So first, I think it's important that the Danish initiative is a government initiative. And it's a part of an initiative that has been agreed in the government program for the current government. It is written into the program. And this government is unique in Danish history, because probably most of you know about Danish minority governments from watching the TV show Borgen. This current government is not a minority government. It's a majority government for the only second time in Danish history, and composed of three parties across the middle of the political spectrum. That's the Social Democrats, it's the Liberals, and then a new party called the Moderates. And this composition is not coincidental, because there is obviously an underlying agenda of keeping both the extreme right and the extreme left out of power by uniting the forces of the traditional parties, with, in this case, the Liberals and the Social Democrats, in this new sort of coalition across the middle. And to maintain power, it's very clear from the written statements as well as oral statements that migration is a major issue. And for them, it is seen as important because they do not want to lose relevance, as has been seen in other European countries, where you've, for instance, seen social democratic parties having very low votes. So those of you that follow these sort of debates, maybe more on political science and law, a lot has been written about particular Danish social democrats turning right-wing and nationalist really in recent years. I would agree, though, this is sort of a partial truth for the simple reason that, in my view, they have been nationalist all the time. First to beat the communists and later to maintain the extensive social welfare state. And this is precisely important to underline because it's where their stance on migration collides with the European Convention. It's in a way where the European Convention comes into the equation. So, as said, the current initiative is written into the government program, but it has to be understood as part of these broader political, dynamics and resembling what Alice was already saying about the United Kingdom. But there's a novelty too, because in the program, it's set out that they should hire a so-called convention ambassador who has to be recruited to have a critical look at international legal commitments. That person is now recruited, but it, interesting enough, did not seem to be a priority of the government because it took them several years to recruit this convention ambassador, and actually only after they got pressure from the far right that they were not delivering on their promises. There is also, and this is very important vis-a-vis what Alice just said, a significant difference between the Danish stance and what you find in the United Kingdom. And that is that the critique of the conventions is not about leaving the convention. Secondly, it is not part of general Euroscepticism, at least for the government parties concerned. Actually, support for the European Union in Denmark is on an all-time high, to a large extent an effect of Brexit and then later on the Russian conduct. So the only parties that have aired the idea of leaving the convention is the far-right Danish People's Party and a new party known as the Danish Democrats. Both of them fairly small parties for the time being. Thus, for most of the parties, when they're critical about convention, it's about reform. And for almost all of them, when they're critical, it's about migration. And more specifically, when they're critical about migration, it's about expulsion of what they term foreign criminals. So the playing field is very different from you see in the UK, and therefore also so are the objectives. Of course, everything I've said so far was observable for commentators in 2017-18 in the processes leading towards the Copenhagen Declaration, although the difference was it was a minority government back then. So that begs the question of what is then new in the current configuration. I think the biggest novelty is the approach. And that part of that approach is a hiring of professionals to take care of it from diplomatic circles, rather than the last time using ad hoc diplomats with no diplomatic training from Minister of Justice. And then perhaps even more significantly, the attempt to create coalitions from the get-go. So you could say, and we would probably write that in a few years' time, this reflects experiences from both the Brighton and the Copenhagen processes. So in the Copenhagen Declaration, the process was very bottom-up. This time it is very top-down, which is illustrated by the fact that the Prime Minister herself went to Italy to present the letter together with the Italian counterpart, Meloni. So where the strategy seems to be a bit shaky is about how to really realize these objectives. And I think, and I read your piece yesterday, and all these rumors about different sorts of agreements, they are probably true. And I believe they're actually reflecting that at the time being, there's being looked into various solutions. So if you ask me, what is the most likely outcome of all of this? I would strongly suspect it's a declaration of sorts pertaining to the convention's relationship to migration. It would be a signal to the court, like all the others, sort of evoking a sort of consensus among member states, if one can be found, but not much more. And I'm saying not much more because to find the unity in the Council of Europe and the effects of overall diplomacy, that would take care of that the compromise that will be stated in such declaration will be, you know, from the perspective of the critical governments, pretty watered out. So my stance right now is that is where it's going. That raises then another question: what is that's been already raised here today by Senator Bodnar and Alice Dahl? So what is the right machine room for all of this? So obviously there's already a platform that's already been evoked, you know, that would seem the most likely one to use. I'm not so sure that's the one they're aiming for. And there's two reasons for that. The first is they want more speed than what is normally considered being the effect of using the steering committee. And the reason they want more speed is that they have set up this whole program with the ambassador, and there will be an election next year in Denmark. So they don't have time for waiting for that. That then opens up for a different pathway, and one you can actually find in the Copenhagen Declaration, which is the so-called Crocodile Dialogue, which is sort of massive meetings involving civil society experts, government officials, and then the judges from the court and from the Council of Europe. So it has, I don't think that has been decided, but I think it is right in front of their nose to do that. So there could be a likely pathway towards reform, but that would then change the whole dialogue because it will be out in the open then. It would not be behind closed doors. I think my time is out here, but thank you very much for your attention.
Thank you, Mikael. Extremely insightful, I must say, and in a sense reassuring. But you know, of course, the question really remains how far such a declaration would go, whether it would involve all states. But I think you frame it extremely well by linking it to the domestic political process. So despite what I said at the outset about being dispassionate and apolitical, we simply can't avoid it because that's the environment in which human rights exist and are realized. Mikael, thank you very much. I'm going to turn now to Veronika, if I may. Veronika, you've spent a lot of time studying the dynamics of compliance in countries where the rule of law was under attack. Could you maybe share with us your views on the current trends and whether you think the situation is qualitatively different to what we've seen, you know, in the past? Mikael mentioned Brighton and Copenhagen. I'd really welcome your views on that. Thanks, Veronika.
Super. Thank you so much, Andrew, and thank you so much for having me. So I, together with my team, have spent the last 6 years traveling around the Council of Europe, talking to different officials and to people who work on execution of judgments of the European Court of Human Rights. And we've done this analysis not only in the rule of law countries, as in countries that have gone through a sort of an attack on the rule of law, but also in Western countries like the UK and Denmark. And we've really, our aim has been to understand how behavior spreads around the Council of Europe, specifically in relation to the European Convention on Human Rights. And in that context, I'd really like to sort of make 3 points today. My first point is that I think it seems to me that we're living in a different moment in time to the ones we've had before, in a particularly sensitive moment. In a number of countries we've studied, we've seen in the last 5 to 10 years, a behavior of hesitance and avoidance turn to a behavior of resistance. And I think Alice really beautifully described what has happened in the UK. The fact that we have been discussing withdrawal for about 10, 15 years, but now this debate has entered mainstream with people across all sides really talking about needing some sort of a reform. We've seen the same sort of pattern in Hungary, where we've seen regimes actively avoiding ECHR challenges or judgments, and then that turning to resistance and open challenge of the convention. Mikael has talked about Denmark, and there's a number of other countries. Now, these are only some examples, but in fact, from the discussions that we've had across the different countries, it seems to me that the letter that 9 countries signed in May of this year is now no longer, I'll say, the position of 9, but that is actually their support for that kind of position across the Council of Europe. And on the basis of the last counting I did, there's about 20 to 23 states that currently support some sort of reform to the system and are actively looking at the options on the table. So that's my first point. My second point is that I think we're now at a tipping point where the behavior of resistance in certain pockets of the Council may spread to other states. So in our project, where we studied compliance and non-compliance of states around the Council of Europe, we did a lot of simulations to see how that behavior, how countries imitate behavior of their neighbors or countries they're linked to. And what we found is that negative behavior, in our case, behavior of non-compliance, is much more contagious than positive behavior. And that is partly because of negative bias, but it is also partly because I'll say non-compliant behavior requires less of states. But it's also what Mikael talked about, which is that states are increasingly creating cliques and friendships between leaders and states. And so it is this kind of behavior now that is spreading across. So, and I think it's what we're witnessing today. But I think, and I think this is why this moment is really crucial. Now, the fact we're talking today about how to reform, it almost implies that we have accepted that a reform is necessary. And I think we really need to sort of drill down what about the ECHR needs reform. So what is it that states are seeking to fix? I've heard a number of officials talk about case law from 20, 30 years ago, but these are judgments that the European Court of Human Rights considers core. And in a number of cases, also like the UK Supreme Court showed in Rwanda, some of this is protected by other international law. And so reforming the European Convention or withdrawing from it actually wouldn't lead us to the result that the states are pursuing. It wouldn't fix the problem, so to say. My third point then is that I think this is a very dangerous moment because of the slippery slope we're facing. If we look at the different options on the table, there are really three realistic reform options. That is a declaration, as Mikael talked about, a subsequent agreement, and then a withdrawal. But I think it's important to understand that these are not mutually exclusive. As Mikael talked about, at the moment, the sort of the option that is on the ground seems to, and for which there's most support, seems to be an interpretive declaration. But once this is done, from what we're seeing in simulations, is that states can realize that they've created enough of mutual support and energy and enthusiasm to push for a subsequent agreement, an agreement that would restrict and reduce the current protection of human rights across the Council of Europe. I think it's important to kind of know that such an agreement would require unanimity across all of the 46 member states, because it would reduce the rights protection that we currently have. And that unanimity would be required even before ratification and signature. And so it is likely that unanimity wouldn't be reached across 46 countries. And what would happen in that case, what it could lead to, is really certain states trying to leave the convention and going for withdrawal because they were not able to reach reform. And so I think it's important for us as scholars really to do a few things. First, I think this is a great opportunity for us to inform the current debate, not only about how the reform should take, but what about the convention really needs reform, and in what senses the convention is different from other international law that we really have. And that is to be done so that we actually, any reform that we put through is actually meaningful. The second point is I think we really need to think carefully about the danger of contagion. That's what we've seen, and the race to the bottom. We have some levers to prevent some of this behavior. So within the EU, if the EU joins the convention, that would resolve the question of withdrawal for EU member states. But on the other side, I think we need to do also what Adam did, which is we need to articulate anew what the convention has done for our continent, what kind of values it protects, why these values are important, and how it has made a positive difference to many of us on the ground. Thank you.
Veronika, thanks very much. I think it's quite poignant what you say there about the danger of contagion and the risk of the race to the bottom. I think that actually reminds me of what Alice said earlier on about the fact that this question of undermining the ECHR has become a kind of virility test, you know, without actually thinking about the facts of, well, what is the ECHR, doing? How is it limiting state behaviour, or what is the problem? As you say, what actually needs to be fixed? We'll come back to you, no doubt, in a few moments, Veronika. But just before we do, my last speaker on my list now is Colin Harvey. And Colin, I want to direct my question to you, specifically kind of focused on Northern Ireland, if I may, because for those of us observing British politics from a little bit of a distance, it's quite striking that neither the rights of people living in Northern Ireland nor the Good Friday Agreement itself seem to feature particularly prominently. So how do you see the current situation, and do you see any risks or indeed even opportunities for Northern Ireland if the UK was indeed to leave the ECHR? Thanks, Colin.
Thank you very much, Andrew, for the invitation. And I want to congratulate you and everyone on the AGORA initiative, which is a really fantastic initiative and well done. It's an excellent question, and I'll try to answer it. I suppose Belfast is a city emerging from conflict, and it is a relatively successful peace process here. I think that's an important starting point. Flawed, imperfect, but relatively successful. So it's a good place to be considering your question today. As Alice has pointed out, UK has had a long-running conversation questioning domestic incorporation of the ECHR, the Human Rights Act, and also the European Convention system itself, and that's well known. And also well known that Brexit may be familiar to many of you. The UK has already left the European Union, so the UK has form in relation to this. So might the European Convention on Human Rights be next? We start really with the story of failure. The attempts to replace and repeal the Human Rights Act domestically have thus far failed. References to potential withdrawal from the European Convention on Human Rights, periodic references, have thus far been unsuccessful. And I think that story of failure thus far is an important framing point for this discussion. But as has been pointed out, as Alice has illustrated, the debate is growing louder and louder once again. And it seems to me, and you'll know, that there is very, very obvious and prominent legal and political groundwork being prepared now for a future Westminster government to take this rather alarming step, right? And you can see that in some of the legal political debates that are going on even this week in the Westminster Parliament. As we also know and should be aware, there are many, many ways to erode a culture of human rights short of withdrawal from a treaty regime. And we should be mindful of all those other ways in which human rights culture can be eroded too. So why is the context of Northern Ireland, which I'm addressing, so significant, and why is it important? Well, Northern Ireland's a post-conflict region. Our peace agreement from 1998 has been globally acknowledged and widely praised across Europe. During the Brexit negotiations, the European Union, as you know, placed very strong emphasis on the protection of our peace agreement, reflecting grave European-wide concerns about a threat to our peace process, including the diminution of rights and equality here. Our peace agreement is about law, but it's also about politics too. It's a bilateral treaty between the UK and Ireland, which is essential to stress and underline today. These are international legal obligations, a solemn commitment made by both the UK and Ireland to support and implement that agreement. So in other words, the European Convention on Human Rights is hardwired into our peace process, and it was hardwired long before the agreement in 98. And I think that framing is essential, and it's what I want to stress here. The European Convention on Human Rights as an essential ingredient for stability and the achievement of a successful and sustainable peace project here. That message is as vital today as it ever was. From dealing with the legacies of conflict in a rights-compliant way to reform of policing and justice, our peace, let me put this starkly, is unthinkable without the contribution of the European Convention on Human Rights. The convention is textually present in the Good Friday Agreement, conceived as a safeguard for democratic power-sharing institutions, proofing of key decisions and legislation, and as a vital constraint. Note the framing. The European Convention on Human Rights is a democratic safeguard. There's also a commitment of the UK government to incorporate the European Convention on Human Rights into Northern Ireland law, with direct access to the courts and remedies for breaches of the Convention. Going further, a Bill of Rights was anticipated here that would supplement the European Convention on Human Rights. That Bill of Rights was never achieved, but it underlines the significance of the European Convention as an absolute floor for our peace process that people are talking at the moment about potentially removing. So we have a special arrangement for peace in Northern Ireland that helped shape the additional special arrangements that were designed during the Brexit negotiations that, you know, necessitated a protocol to the withdrawal agreement, now referred to as a Windsor Framework. Now, why am I telling you all of this, right? You know it all already. Why stress this today? I think it's a good opportunity to underline the overall legal and political framing regarding the European Convention on Human Rights in a positive way, not just for Northern Ireland, but across Europe. The Convention and its mechanisms are central to the peace project here, essential for the present and vital for the future. Think about that. The European Convention on Human Rights as intrinsic to stable, sustainable, and successful democratic societies. Broaden that out, the European Convention on Human Rights as central to a positive policy agenda about peace. Now, conservative critics, as Alice has pointed out in the UK, going back 20 years, the themes that they've been emphasising are evident in the European-wide debate, and contagion has already been mentioned by Veronika. The playbook is familiar, in other words, right? So this is not new. The policy areas that are targeted are not new and not novel. Migration, counterterrorism, criminal law, public order. So the present backlash culture that we're facing has an extended history. But as we know, and as everyone has underlined today, the critics of the European Convention are increasingly finding their voice across Europe again, using all the technologies of communication that are available to them to spread that message. But I would say that the evidence from Northern Ireland and the evidence from the UK thus far, right, is that that critique and those attacks can be met. The story in the UK is largely, not entirely, one of failure. The Human Rights Act is still there, and the UK is still signed up to the European Convention on Human Rights. So arguments can be met and they can be defeated. So I just want to end with a question, a framing question that ties into what has been said already and to extend out the Northern Ireland context. What precisely are the democratic values, right? What are the democratic values that human rights defenders are struggling for across Europe and everywhere in this age of really, really vicious authoritarianism? To put that rather starkly, what are the values that we are struggling for and defending? And I suppose the message from Northern Ireland is that the European Convention on Human Rights is an essential positive shield and safeguard for peace and democracy. So I would say that Northern Ireland is a small region, but it's a small region with a potentially very big message for Europe and the wider world. Thank you very much.
Thanks, Colin. And I think it's quite striking for me and probably for many of the participants just how utterly at odds what you're saying is in comparison to the political narrative in the UK. That the messages, the fundamental messages you're talking about, the centrality of the ECHR for the peace process, for a cohesive society, for prosperity in the North, just don't seem to be getting the airing that they deserve, and without really sufficient pushback or counter narratives from opposition parties or others. We will come back, no doubt, Colin, to you in a moment. I'm going to, first of all, just thank all the panelists for their first interventions. And we're going to go to questions now, a couple from myself, and then we'll throw to the floor. But before that, can I just invite Professor Federico Fabbrini, who's the director of the Dublin European Law Institute, to offer the first question. Federico, over to you.
Thank you so much, Andrew, for giving me the floor. I am abusing my position here, but it has been a fascinating conversation, and I wanted to thank all the panelists for their excellent contribution. I suppose I speak here with a double hat, and I'll start with a joke, because when Andrew originally approached me to suggest that we would organize the event, he said we should present it as a Dublin European Law Institute event, and I am the founding director of the Dublin European Law Institute, but as many of you will know, I'm also the founding director of the Brexit Institute, and Andrew was very reluctant in using the word Brexit Institute as a framework for hosting this event. And I'm sorry, I'm using this as a joke, because that's really the question I want to pose. I think, in light of the conversation that has been playing out so far, we could have presented this as a Brexit Institute event, because I suppose, and that's really my question to the panelists, that really the issue seems to be primarily a British one. It does affect other countries, but to a much lesser degree than it does the United Kingdom. And so perhaps what we are discussing really is the tale of a very exceptional British approach to Europe that, of course, has revealed itself through Brexit, which kept us busy over the years, and is now continuing with the ECHR. At the end of the day, if we think about it, Theresa May was in favor of remaining in the EU back in 2015, but in favor of leaving the ECHR. So already 10 years ago, I think all the elements were there. And so I wonder, to put it explicitly, is this just a British problem again? And at the end of the day, is it really new? And here I want to mention Mikael Madsen, because I had the privilege of working in his team over 10 years ago at iCourts in Copenhagen, where I was associate professor. And I remember we were discussing already these things. I mean, the iCourt, the Center of Excellence for International Courts, where I've learned so much, was established precisely to deal with the backlash against the European Court of Human Rights. So to what extent is this primarily a British malaise, and to what extent is this something really new? Although, having said all that, I think it's very important that we discuss those points. So once again, fair play to all of you and congratulations. Thanks,
Federico. I could put that to anybody, but maybe Alice, could I start with you just on that particular point? And also just while we have the opportunity, and maybe also Adam then afterwards, we saw yesterday, Alice, maybe did we see a little chink of hope where the Farage proposal was voted down, which seemed to have the support of the Tory party as well. So is this just a British problem, and is there a sliver of light creeping through? Alice.
Thanks. Yes, I'm sorry to bring the mood down again, but I don't really see much light from yesterday. Let me just explain what happened. And by the way, thanks for your comments, Federico. I'm reminded of the title of a book by the wonderful Conor Gearty, who we all miss so much, where in the UK was called Fantasy Island, which I think sums up this kind of British exceptionalism, which has now kind of gone into overdrive. But what happened yesterday, just to fill those of you in who weren't aware, is that Nigel Farage used what's called a 10-minute rule bill, which is kind of a motion that an MP can speak for 10 minutes to in the Commons. And it's a way for MPs to kind of put an issue on the agenda. It's more or less symbolic. It doesn't go anywhere. Doesn't have any legal weight, and it won't be given parliamentary time. But he used it to push a motion for the UK to withdraw from the ECHR. So what happened? It was defeated. But I think the reason I don't see much light from that is twofold, really. One is that the Conservatives gave it some, the Conservatives were very present for it and voted, of course, with reform, which we don't know where this will go, but it might signal some kind of accommodation between the two parties on this issue. This goes to much wider politics, of course. If the Conservatives move ever rightwards, they're either in hot competition with reform. They kind of have to either eat each other or merge, essentially. So there could be a warning sign there in terms of the two parties coming together and using this as a platform on which they're united. but also the disarray, or maybe not disarray, but the uncertainty of Labour's handling. So initially, the Labour Party instructed MPs not to attend this 10-minute rule bill debate or event. I suppose to not dignify it in a way, give it the credibility of being present. And indeed, it was the leader of the Lib Dems who spoke against it. But what happened was that a number of backbench Labour MPs were alarmed about the fact that this would then pass as a motion and be on the record, even if it was rather meaningless. And so they did, in fact, attend in enough numbers to vote it down. But, you know, the whole thing was rather kind of uncertain and it sounds like a bit of a scramble at the end to ensure that this motion was defeated. So I'm not sure so much that it gives us great hope in that sense. It's just part of the drama playing out. Will I go on to address the second question?
Maybe briefly, Alice. Yeah, do you think it is something that's just a UK problem or broader?
Well, I mean, I think Veronika actually spoke to this perfectly in terms of this risk of contagion, and that the momentum that might accelerate that contagion now seems more dangerous than it has in previous years. I think it's not new exactly, but I think there's a coming together, particularly with this, you know, kind of instrumentalization of the migration issue. So yes, I think there certainly are particularities in the UK, and certainly at the moment it's important to stress that, you know, the Conservatives as a centre-right party, for now at least, are completely an outlier in European terms on this, whereas Reform, of course, is already swimming in the same waters as some of the sort of radical right parties. But I very much heed the words that, and indeed the research that Veronika's done on the risks of contagion.
Thanks, Alice. Adam, can I turn to you? Is this a British problem?
My feeling is that it was always British problem, and it was part of, I would say, bigger British debate concerning the principle of parliamentary sovereignty. We remember the whole discussion about implementation of Hirst case, Green's case concerning prisoners' rights. And I remember that some time ago, more than 10 years ago, I remember how painful it was for Eastern countries that UK started this debate, because it provided like the good avenue for such countries like Ukraine to escape the obligations concerning enforcement of judgments of the ECHR. And that was the reason that basically UK argumentation, maybe sometimes based on some constitutional or maybe sometimes even good faith arguments, were quite painful to the whole system of the convention. So I was quite happy that UK ultimately decided to drop this topic, but unfortunately this topic came back just recently. When it comes to the Polish debate, please look that we are also surprised by this recent interview by Polish Prime Minister for Sunday Times. It was quite unexpected, to be honest. But on the other hand, please look that there was this famous letter of 9 prime ministers concerning the need to kind of reflect on the migration and the system of the convention, the consequences of judgments of the European Court of Human Rights. So once again, we come back here to the question of migration and some possible consequences of not only existing judgments, but also future judgments that would evaluate some practices at the borders or practices concerning outsourcing of the refugee problem. So because this problem is much more, I would say, general, not concerning just one single state, but a couple of states, then basically it could infect the whole debate on the future of the.
Thanks, Adam. And I think Mr. Tusk's comments also surprised a lot of us, but it does seem that there's been some clarity brought to that matter since then. Mikael, can I turn to you, please? And actually just building on a question that has come in through the Q&A, I should acknowledge, by the way, the comment box doesn't appear to be open, so the Q&A box is fine. If people do have questions, please do put them in there. One of the questions that came in, Mikael, relates to actually the scope of the problem. And there's a question being asked about, is the actual problem of migration just simply being exaggerated in Denmark, or is there a real issue there? That's the question that's been asked by one of our participants.
Well, so I think that you have to separate the question between the question of migration politics and policy in general, and where the European Convention has any possible impact on these issues. And where you find it for the European Convention, of course, is via Article 8 and in some instances Article 3. And if you look at the number of cases, if you use that as a benchmark, it seems rather insignificant. Denmark is one of the countries with the fewest cases, Strasbourg, as it's always been. And it's true that most of the cases are about Article 8 expulsion cases, but they are far between. And if you read them very carefully, you will find that they seem pretty much in line with very established jurisprudence. So there's not much surprise there. And then you could, of course, ask the more difficult question, and I don't think anyone has yet answered it, and I'm not sure it's been answered in UK either. It is, of course, that you could dig a little deeper in your analysis. To look at just the cases at the highest court, so the European Court, gives you some kind of indicator, but of course, these provisions apply deep into the state structure. And to be frank, we don't know how much impact they have there. But what we do know is, and I have gathered the paperwork, from the prosecution service and so on, it is that they go to the limit in their execution in their practice, basically, meaning that they use fully the scope for the state in those regards and the various margins allowed. So from a purely objective, scientific perspective, the biggest problem about migration has very little to do with Article 8 or Article 3. They are just very visible. And it's where, in a way, to connect to Federico's question, is it just UK? Well, it used to be just UK, but no longer, because the UK, tabloid technology has been imported elsewhere. So the spillover effect of the UK, where you have been bashing the court in this kind of cases, for decades now, is precisely what's happening in other countries. So even though the cases are far between, and sometimes they don't even go to the European Court, actually, the most famous one, Denmark, most people believe is a European Court case, is actually from the Danish Supreme Court. But they're being bashed, so whatever you call it, the Strasbourg bashing, as that was a very specific UK thing for decades, is now also found elsewhere. And that sort of means that what is UK, and of course, as you can tell from Alice and my own intervention, are different political agendas, but they get mixed up. And partly because the same arguments being used, and that some of the actors from the UK are quite happy to travel over the channel to present the arguments as something that is equal in other countries. So there is definitely an importation of the UK situation elsewhere, even though the actual situation is different. Thank you.
Thanks, Mikael. I think it's a resounding no then to Federico's point about is this a British-only problem? I think we probably all agree that it's a bit broader than that. I think it's important, though, to remember that, this whole question of retreat from the Council of Europe standards became really mainstream after the Turkish withdrawal from the Istanbul Convention, which I think never really received probably the attention that it deserves. But anyway, I digress a bit there. Veronika, can I turn to you for a moment, please? One of the questions that came into the chat box, it's something we addressed, myself and Alice, in the EGIL piece yesterday, but I'd really like to hear your views. One of the questions was, is there an alternative reform strategy? Could a state just leave the convention and re-ratify on different terms? That's one thing. And then the other thing I'd like to hear from you about, if you have some thoughts, is, do you think the Council of Europe and member states should be just doing more to try to counter this negative narrative, or would that in itself nearly be counterproductive? If you have thoughts on those, I'd really welcome them, Veronika.
Thanks so much, Andrew. So just on the previous question, I think it would be wrong of us to think this is a UK problem. I think we now have sufficient evidence that this is actually half of the Council of Europe. On the questions you asked about re-ratification with the reservation and on what Council of Europe can do. So I think the really important move that can happen in the next few months that would take the withdrawal option off the table to a large extent would be EU joining the convention. I think for the rest of the EU, that would resolve the problem of withdrawal being an option. But it could also, from what I understand, because Article 2 of the treaties of the European Union mentions and talks about human rights, it would also open any reduction of human rights to a challenge in front of the Luxembourg court. So if any reform were to take place that would reduce the protection, that would then end up in front of not the General Court, but the Court of Justice of the EU. So that is one of the things I think that would happen. In terms of other things and other levers we have, I think one of the things that concerns me is what Mikael talked about, and that is that states are now increasingly taking this discussion outside of the Council of Europe framework. I think that, and that they're creating cliques, and these cliques are getting bigger and bigger. So I think it is important that actually we foster and help the discussion within the states that we operate in, and that debate is improved, or that we contribute to debate within the member states in which we function. Because it seems that this might not be done as a movement at an international level, but actually that there's an incentive to do it state by state and in these groups. So I think it's important for us to speak to governments, to speak to officials, and to make the case of what is the reform that is being sought, and would the processes that are used actually achieve what we're looking at or not. And I think specifically on the reservation point, one of the arguments that was made is that essentially withdrawing from the convention and rejoining is essentially an act of bad faith that would not be allowed under the convention and other EU law. So I'll stop there. Thank you.
Thanks, Veronika. Thanks very much. And time is absolutely flying. So I'm going to propose that we do two final questions. And I acknowledge we won't have covered everything in the chat box, but perhaps, Charlie, you could share the EGIL article. That will probably help answer some of the questions, but certainly not all. But I appreciate the engagement. Can I turn, though, Colin, to you before I maybe return to Adam? Because, and I suppose, looking ahead, next year is a big European year for Ireland. Ireland takes over the EU presidency. Of course, the EU is a separate organization from the Council of Europe, but nevertheless, there's an inextricable link on some of these issues. Can I ask you what you think Ireland's position should be on these matters? I mean, Ireland has been pretty quiet, I think, strategically in relation to the whole ECHR withdrawal debate and the UK and the implications of GFA, at least outwardly, maybe a lot happening behind the scenes. What do you think Ireland should be doing on this front? Should it be doing more? Does it have a role in this discussion?
Well, thank you, Andrew. It's a great question, particularly given Ireland's role in the second half of next year in terms of presidency Council of the EU. But look, on the question of the arguments, this isn't a UK confined issue. The arguments are spreading, and beyond the world of law, what we're witnessing is almost like a political retreat from the language of rights and engagement, even among those who historically would have been comfortable deploying the language are less comfortable than they were. And I think it's evidence that some of the arguments you see in the UK are not confined to the UK. This is going across Europe and well beyond. Obviously, I focused on the Good Friday Agreement to make the point, looking at the world we're currently in, a world of conflict, militarism, and war, that in our small region, the European Convention on Human Rights is central to peace here, to stability, to sustainability, and success of power sharing, democratic institutions, and democratic societies. And I think that's a message that Ireland, particularly, the Good Friday Agreement, the bilateral treaty is between the UK and Ireland. Ireland has a particular role now and in the years ahead, and has done, to be fair, in carrying that message to Europe. I suppose the Taoiseach Simon Harris, actually, if you have a look at remarks from the British Irish Association in Oxford recently, did actually underline there to the British government that the European Convention on Human Rights is a fundamental safeguard of the Good Friday Agreement. It reflects, I'll read it, it reflects Ireland's and UK's shared status as founder members of one of the key parts of the European legal and political architecture that emerged from the shadow of the Second World War, the Council of Europe. So there we have a practical example very recently of Simon Harris, the Taoiseach, underlining precisely that point with links to the Council of Europe. Just recently, the UK and Ireland have adopted a joint framework on legacy going forward, with the European Convention on Human Rights and Article 2 compliance absolutely at its heart. Why am I labouring that point? I'm labouring that point essentially to take it back to the starting issue around small p politics. Look, we have to win the political argument as well as the legal arguments across Europe, that the European Convention on Human Rights and human rights in general are absolutely essential for stable, successful, sustainable democratic values. And it's a question I posed at the start. What is it precisely what are the democratic values that we are struggling for against authoritarian regimes in Europe and around the world? Thank you, Andrew.
Thanks very much, Colin. I'm going to come, Adam, do you mind if I come to you for a last set of questions? And I'm conscious that we haven't answered all in the chat box, but we can only do what we can do. So Adam, two things, if I may. I suppose one of the questions that came in the chat box from Ed Bates, I think, is really pertinent. And he says, you know, are we in a position of politics, not law now, and damage limitation? And would it be better just to concede some, you know, limited tokenistic reform to give politicians the feeling of success rather than risking moving, you know, to the brink? I suppose that's the first thing. And then I guess the broader question I have for you is, what would your advice be for Council of Europe member states? Where do you see this conversation going, and what would your advice be for Council of Europe member states going forward? Thanks.
Thank you very much for those questions. First, I would like to come back a little bit in terms of strategy to what Veronika said about this re-ratification. You know, I'm really afraid that if there is going to be a renouncement of withdrawal, there will be no another ratification, taking into account like the difficulty of the constitutional process in different states. Please look that these were different times in 90s, for example, when Central European countries ratified massively the convention. And then we have right now, look at, you know, today we have the debate about withdrawal of Latvia from the Istanbul Convention. That is happening just today in the Latvian parliament. And it is just one of the examples of the approach towards international human rights treaties. When it comes to my advice, I think, you know, if there is a problem, there should be like a political way of resolving this problem and the instruments that are serving this, which is the Intergovernmental Conference. If countries would like to face this dilemma, what to do with the migration and how to tackle this issue from the human rights point of view, they have always this measure to do it. Please look that when the court was accused of judicial activism, there was a debate on what to do with the margin of appreciation in the preamble to the convention. It has been agreed, and the subsidiarity principle has been strengthened in this context. So basically, that is, in my opinion, the proper avenue to resolve problems. Although it may take time, and although it might not be politically beneficial, like from the next day. But still, that is what I would go forward if there is any need. But for sure, I would not allow politicians to undermine the credibility of the whole convention system. And here, I think we come to, you know, because usually in that kind of a situation, you know, we have a question, okay, but who are allies of the convention? Who are the stakeholders that are going to protect the convention? And I think what we forget here, that these are just regular people that took advantage of the convention system, that won their cases, that helped in their situation, and not only just, you know, professional NGOs, not only, you know, lawyers dealing with the convention, but just like regular people that over those tens of years took advantage of the convention system in tiny cases and in big cases. And I think this coming back a little bit to this narrative about the conscience of Europe and this, let's say, story about this human face of the convention is I think something that we should underline. I think right now it is more important than ever. Thank you very much.
Thanks, Adam. That's I think a great note to potentially conclude on, unless anyone has a last burning point that they wish to make. We might move towards Alice. Please take the opportunity.
Really quick point that was sparked very much by what Adam just said. I think we also need to resist the idea that there's a consensus here. I see this in the UK, that there's an asserted consensus. So headlines talk about the hated Human Rights Act, the reviled judges, etc. But even in the UK, despite everything we've discussed, just last week or two, there was opinion polling that showed that just under half the public want to stay in, only just over a quarter want to leave, and the rest are don't knows. So there isn't a consensus even in the UK around this, despite the relentless negativity. And of course, even if there are 23 states who are in favour of reform, that's only half the total. So I think we need to really push back on this assumed or asserted consensus. And indeed, of course, that does mean the quieter voices or the silent voices speaking up. And as Adam said, the sort of humanization and to convey that the convention is about so much more than immigration, which indeed is only a tiny part of its case law.
Absolutely, Alice. And also, I think it's often forgotten that so much of what the convention provides for is exactly supporting a prosperous economy, a stable society. It's not just a question of rights for a certain group versus another. I think that's really important to bear all of that in mind. Right to a fair trial, an efficient justice system, and so on and so forth. I think with that, I just want to say a sincere thanks to all the panelists. This is a very important moment. I think it's clear for me today that we have a long road ahead in terms of this discussion around the future of the ECHR, but it's really important, I think, that we engage with that in a dispassionate way, in a way that doesn't vilify people who have different opinions, but we do insist on having an evidence-based, discussion, an objective kind of discussion on it. I think that's really, really important. That's what AGORA tries to achieve. To close, I'm going to hand the floor to Federico Fabbrini, Professor Federico Fabbrini, and thank you all from my side. Federico, over to you.
Thank you so much, Andrew. On behalf of the Dublin European Law Institute, and I suppose the Brexit Institute as well, let me really thank you for putting together this initiative. Thank the panelists for a fascinating discussion, and thank also the audience, more than 140 people tuning in to listen to the debate. I suppose if we learn something from the Brexit experience is that it's crucial for experts to be vocal, to raise the issue. Perhaps we weren't that vocal or sufficiently vocal back in 2015, 2016. So we should learn from that and be vocal now about the ECHR. And because of this, I want to congratulate you, Andrew and Alice, for the AGORA project. It's a great initiative, and I can confirm publicly that, of course, the Dublin European Law Institute will be happy to continue supporting it also financially moving forward. So I would encourage all the participants to engage with this wonderful project. And of course, stay tuned on the research and policy projects of the Dublin European Law Institute and Brexit Institute, and subscribe to our mailing list so you can know what's going on in Dublin. Thank you very much on behalf of DCU, and we bring to a close this wonderful panel.